Kane, can you hear us?
I can. Can you hear me?
We can. Fantastic. The technology works. Um,
It's
so
always nice when that happens.
Terrific. Kane, it's James here. I'm in a room with about 25 people from community legal centres and legal aid and other legal assistance services. We've also got, we think about half a dozen people tuning in remotely using this webinar technology as well. I might just briefly introduce the reason why we asked you to provide this advice and give this presentation and then hand over to you if that's okay.
Yep, sure.
Terrific. So as I said before, folks, I'm James from Quails. At our September 2015 CLE LAF meeting, a conversation started about the ways in which we could share our resources that we produced, identifying a few concerns and a few opportunities in that kind of work where we were producing fact sheets and others wanted to use that fact sheet, but when would it be appropriate? When could we use other people's intellectual property and what were the implications of that? And so we agreed that it might be a good idea to get some pro bono legal help on what our options might be in terms of sharing as much information as we can while protecting our intellectual property rights. And Kane and one of his colleagues at Ashurst very generously offered to provide a written legal advice, which we'll be distributing later today through the team at Legal Aid, and for Kane to dial in, I guess, and present the kind of substance of that advice and to take some questions from you guys about how we can do this stuff a bit better. And so here he is. Kane's an intellectual property lawyer in the at Ashurst, based in Melbourne. And Kane, thanks again for the terrific advice and for logging in this morning to share your wisdom with us.
Thanks, James. So what I was essentially going to do is very quickly whip through the substance of the advice. I don't want to spend too much time on it because I expect there may be some questions that go to sort of the heart of how it might practically be implemented. We were trying to be quite conscious in arriving to advice at what's going to be the sort of easiest or most practical way to implement a scheme for licensing materials. Obviously, you can get quite formal with this sort of thing. You can put together big documents, big contracts, big deeds, but that's obviously not the sort of perhaps more onerous regime that we might want for community legal centres and legal assistance services that are probably time poor already and don't want to be managing big documents if they don't need to. So what I'll go to first is the substance of the question that we looked at. I should check, James, have we got this on the screen up there?
Yeah, absolutely, Kane, thanks.
Perfect. So we were essentially asked to sort of look at this from a few different angles. So at the core, we understand there are a lot of sort of common written materials that various legal assistance services may want to use. So this may be things like fact sheets. It may be content on a particular web page or a web service. It may be a letter. It may be any sort of pro forma material that's produced by a given legal assistance service that another legal assistance service may want to tailor for its own needs. We've got the example there of top and tailing content where you keep the core, but perhaps put your own letterhead, your own branding, your own contact details on it. And of course, there needs to be some scope to, if you've got a not quite up-to-date fact sheet, perhaps one you found from another legal assistance service that's a couple of years old, whether or not there's scope to actually amend and edit it off your own bat, or if you need to go back to the original author and check with them. These are some of the sort of concerns we looked at and tried to tailor our advice to. The other side of it was that James had flagged from Quail's point of view that there are occasionally materials produced with a view to delivering fee-for-service training. So there may be some materials for which there is a commercial purpose you want to deploy, and we wanted to make sure there's enough flexibility to allow for that for particular materials, but also allowing for other materials to be sort of shared more freely and without too many restrictions. Just a brief touch on, I don't intend to make this a lecture, but just to make clear what we sort of looked at, we really were principally concerned with the copyright that will vest in materials that are put together. And as I'm sure we all know, copyright is something that will vest in literary works, also artistic works, but we're primarily concerned here with literary works. Any particular illustrations, though, on the artistic side, of course, will have their own copyright, and to the extent that illustrations or graphs or diagrams or anything like that may be affixed to a fact sheet, it's important to remember that you may have to deal with copyright differently, or at least make it clear that copyright that is being licensed is both the image and the written work. That's sort of one of those more tricky things that can come up when you've got multiple authors putting together content for one material, and it's just something to keep in mind when we get to the core of what we've suggested as a potential solution to this problem. Another side of the coin is moral rights, which some of you may have come across. Moral rights are a little bit different. They're a different type of IP. They really are almost a sui generis regime for protecting authorship and protecting the integrity of an author's work, and they go to the core of things like attribution. For some of the case law deals with things such as architects being allowed to have a say as to when a building gets changed. It's really to sort of look into the integrity of the original author's rights to the ongoing derivations of a given work. We haven't really intended to go to moral rights, largely because they can't be assigned. They're not something you can simply give away to somebody else. You can waive moral rights, and usually employment agreements or any sort of engagement agreement will deal with that question. So just as a separate thing to flag when we're looking at the licensing of rights between legal assistance services, is it may be a worthy question just to each individually have a look at your engagement or employment arrangements, particularly when you've got things perhaps such as interns who might be at various legal assistance services, and just determine whether or not you've adequately dealt with the question of moral rights, and if not, that might be a separate question to address outside the scope of this presentation. So that's really just to flag the subject matter of what we're dealing with. And as a brief overview, many of you are probably aware of how copyright is dealt with out there in the public sphere by various organisations. The most common way is a copyright notice, and we've probably seen this at the bottom of documents or the bottom of websites quite a fair bit. There are two types of copyright notices, and James has flagged that the advice we provided to Quails is going to be shared among various groups, and we've given examples in that advice that flesh out what a copyright notice looks like, but they do come in two forms. There's a bare assertion, which is simply where you are writing on the document or on the website that copyright vests in this material. It's making clear that copyright is asserted and who the organisation or who the author is for whom copyright is vested in. And it doesn't offer a licence. It's merely putting the reader on notice that this is a copyrighted work. Their licenses are similar. They are structured much like a notice. You put them down the bottom of a work. It's in written form, or it might be at the bottom of a website, where you assert the copyright, but you then provide the terms on which it will be licensed without further communication to the party. So this might be something along the lines of saying, copyright vests in Quails 2016. This work may be used as long as it's for non-commercial purposes and the work is attributed. Very simple terms on which it's allowed to be used by anyone who comes across it without having to contact Quails directly. So copyright notices are an option, and they may be that for particular works they're something that a legal assistance service would like to adopt. We don't think it's necessarily a complete answer to the sort of flexibility and sort of questions that were addressed to us, but that certainly is an option. The other common way of dealing with these issues is a cross-licensing deed. So that's where multiple parties come together who all have materials that they have authorship to. They're materials they would like to share within the group, and you can have a formal deed, which is a formal multi-party contract or document, I should say, which makes clear, makes explicit what are the materials that are being shared, on what terms are they being shared, who is a party to the deed, and who may use those materials. This we thought was a bit too formal, perhaps a bit too structured. One of the problems with a cross-licensing deed, of course, is that if there are new parties who are going to join the sharing, as it were, or parties that might move out of the sharing relationship, or if there are new materials being produced all the time, it would require, to some extent, a revisiting of that deed from time to time to update it. And that's quite an onerous logistical and administrative task, and it perhaps doesn't provide that flexibility that certainly James made clear that Quails thought was necessary for addressing this sort of question. The other option, which, as we'll see soon, we've decided to recommend, is the Creative Commons scheme, which some of you may have come across, and I'll be spending the rest of this presentation essentially getting to the guts of what Creative Commons is and why we think it's this scheme that provides the flexibility that the legal assistance services, such as Quails, may be wanting to utilise. So the scheme is really dependent on determining what is the intent or purpose for which the material has been created. And that's because there are many different ways of licensing under Creative Commons. It's best perhaps thought of as almost a smorgasbord where there are various terms which are all lined up, and you can go and pick and choose which terms you think are appropriate for the license for a particular material. So it does give you quite a fair bit of flexibility. The other beauty of the scheme is it's free to use. Creative Commons is itself licensed on Creative Commons terms, so people are able to use and adapt all of the materials that are put out there by the Creative Commons organisation when they're looking to license their particular materials. It's very simple to use. One of the other things James had flagged was that we don't want some big, long, scrutinised by 18 different lawyers disclaimer that takes up half or a third of a page that you need to affix to all your materials. That's not very useful. It's not very practical. The beauty of the Creative Commons scheme is there are a set of pro forma symbols which are small and unobtrusive, easy to recognise, easy to understand, which you can implement, which signify that that particular Creative Commons licence is being used for that material. And we'll come to those symbols in a moment. The other useful thing about Creative Commons is that there is a flexibility inbuilt into whether or not a given material is to be licensed purely for non-commercial use. So that is to say, legal assistance service might say, I want to put this fact sheet out on my website for the public at large to use, but I'm not entirely happy with the idea of someone coming across, picking it up and popping it into their training seminar that they're going to make money off. I want it to be purely for non-commercial purposes, and that's a decision, or that's a flexibility that you can build into determining which license you want. The only qualification in Creative Commons, and this is certainly true of a lot of license schemes, not just Creative Commons, but it's irrevocable. You're putting it out there. Material licensed under Creative Commons will enter the public sphere, and it will usually be shared alike on similar terms or non-similar terms. And once you sort of put it out there in public sphere, much like any other fact sheet that you publish to a website without any copyright treatment, it's out in the public, and you no longer necessarily have control over the ultimate fate of where every copy of that material will end up. So Creative Commons. This is going to be a table that's in the advice we provided to Quail. So if James, as he's flagged, is going to be sharing that advice, you'll have this table to refer to, so no need to scrutinise it too closely. But this essentially goes through the various types of licenses that are available under Creative Commons. And you'll see that there are various inputs, if you like, or modules that you can pick and choose from to come up with the license that you like. The first of which is attribution, if it's important to a legal assistance service that their work be attributed, if it is copied or used in some other form. That's one of the ingredients that you can include in a Creative Commons license. Share alike is another common one. It's not uncommon for people looking to license under this scheme to insist that you can have it and you can use it yourself, but only if you also license under the same terms. And that's to ensure that work which is intended to be used in the public sphere, it's intended to be accessed by people at large, continues to be. It doesn't get locked away in some sort of derivative work or other use down the line. Derivative work is another thing you can determine with Creative Commons licensing. You can decide whether or not you're happy with other assistance services or other people at large creating derivative works, that is taking a material you've authored, chopping and changing it, making modifications, updating it, and that'll be a particularly important consideration for that top and tailing idea that was canvassed in the initial instructions, and also where you're wanting to update materials, so where you have found that 4 to 5 year old fact sheet that is really good and you think it's useful for your given purpose, but you might just need to tweak it and update it. Whether or not derivative works are allowed is going to be an important question. Then we come to the idea of being non-commercial or commercial. And this is obviously very important when you are looking to determine how you want a particular fact sheet or a particular publication to be used, whether or not you're happy for somebody to take it and use it for whatever purpose they deem fit, or if you think it should be confined to only non-commercial purposes. And the other side of the coin here will of course be where there are materials that Quails or any other legal assistance service would like to use for fee-for-service purposes. It may be that those materials aren't licensed under Creative Commons at all, you want to hold those back, or it may be that you're seeking to allow them to enter the public sphere for use by average consumers and citizens, but you're also wanting to leverage those for commercial purposes yourself and not have anyone come in, take them and use them for commercial purposes in a competitive sense. So that's another ingredient that we can use to plug into which Creative Commons license is best for a given purpose. Now, what I'm going to do now is just pop over to the website for Creative Commons, because I think it's something that makes a little bit more sense, and you can put a bit more flesh on the bone when you actually see how these licenses are implemented. And the website itself is a really useful tool. I think it's probably one of the better of its kind going around. It is really user-friendly. It explains everything in a simple manner, and it enables anyone, irrespective of their level of legal education, or indeed intellectual property specialisation, to readily understand what the different licenses do and to go through some mechanisms to determine which license is best for them. So the Creative Commons website is creativecommons.org. What I've gone to on this page is just up at the top, you may see the green banner. There's an option, licenses, and choose a license. And this is a really useful tool for anyone who might be working in your organisation, be it one of your staff members or interns, who's having to have a look at a particular material and determine how best to license it. This gives you a very easy sort of flow chart interactive mechanism for determining which ingredients from that smorgasbord are going to be relevant to you, and then it'll pop out with a really easy to use symbol that you can then affix to your materials, which represents that particular Creative Commons license. So you'll see on the page here we've got license features, whether or not you would like to allow adaptations of your work to be shared, and there are the options yes, no, or yes as long as others share alike, which is that idea of the terms having to be the same for any subsequent license down the chain. Whether or not you will allow commercial uses of your work, and let's just try some of these different ones, and I'll show you what happens there on the right. It will change up the symbols and change up the name of the license that's been chosen based on those selections, and you'll see these symbols each refer to one of these sort of units, one of these ingredients for the license. So we have the first noting that it's a Creative Commons license. We've got here a symbol of a person, which is for the attribution. Then at the very end is the circle repeating back on itself in a counterclockwise direction. That's the share alike. And the dollar sign with a line through it, non-commercial. And there'll also be a link here, attribution non-commercial share alike 4.0, which refers to the particular type of license that's been selected. There are various iterations of Creative Commons which are released over time as the Creative Commons Foundation updates the terms to keep track of various developments in the law. And if we click through on this one, there we go. This is a useful page for each of the individual licenses for a number of reasons. Firstly, it gives all the relevant definitions right off the bat. One of the obvious important ones for organisations such as Quails may be determining what actually is meant by commercial purpose, as largely not-for-profit organisations, whether or not something is commercial is often a bit of a contextual question. Commercial is very broadly drawn, though, in the context of Creative Commons licensing. If we click here, it may be a bit small on the web page, but you can have a look later. Commercial is determined as any use which is primarily intended for commercial advantage or monetary compensation. So it is something that a not-for-profit organisation can engage in, as long as there's a fee or some sort of pecuniary compensation coming back to the organisation providing the service. That's sufficient for it to be deemed commercial, and therefore the non-commercial commercial dichotomy within these licenses will be enlivened. The other useful thing about these pages is that it will take you to the full set of terms of the license. So this isn't just simply a symbol you affix that doesn't give any sort of context or meat on the bone or any sort of legal rights. It is a fully fledged legal deed. The license is published on the website, and the idea is that those symbols provide notice that this particular license applies and allows users to choose or to consent to be bound by the terms as published on the website should they use the material subject to the license that's been affixed. So instead of having to put all of the scroll and all of the license and all the terms as a side note or as a side document to anything that's published, it allows it to be put here unobtrusively where people, should they wish to come and have a look, can determine the very specifics, the line by lines of the license and how it works and how it might interact with various legal directives around the world. But if that's not necessarily something they're wanting to get into the nitty-gritty of, they're simply wanting to use the licensed work for a particular purpose, it should be readily ascertainable by the symbols which are affixed to that work, whether or not they're able to use it in that manner. So this is a useful website for, I think, people or staff members within various legal assistance services just to get a feel for how the Creative Commons system works, and perhaps if they're on a bit of a line ball sort of call as to which Creative Commons license is going to be best for a given work, delving into this more detailed version of the deed may help provide some insight. But on a more practical level, the website itself is quite useful really for this feature, if for nothing else, and particularly for content that's going to be put on a web page, because it allows you to very quickly get some HTML code which you can pop into your website, which will not only give the relevant symbol that you may have chosen, but is click-throughable to the relevant license, such that persons who come across that work who are wanting to use it on that license term have access to the relevant license just a click away.
Okay.
Kane?
That's interesting. Maybe everyone.
When you hook in next week, or
Yeah.
I might do like, click start.
So I didn't quite catch that, James. Was that a question?
It could have been, who knows? I'm going to shake your head. Some weird interference, we're being told. Kane, I'm not sure if I've given you a bum steer around the timing. We've got 5 or 10 minutes left.
That's fine. I was going to move on to a few examples, if that's okay, and then we get some questions.
Yeah, that'd be great. Thank you.
Excellent. The only other thing I'll say on this website that's quite useful is individual organisations can include the title of the work and the name of the work, and that'll be inserted as metadata into the code, such that it will be inserted and attributable to that particular work on a website. So particularly for organisations that might publish a lot of their works via web forums or via websites or through web interfaces, this is a really useful tool for ensuring that rights and attribution are maintained for a particular legal assistance service, but also allowing for that flexibility as to which license to use. I was going to very quickly have a look at some of the examples that James usefully put through to us as to how Creative Commons might be used. First off, we have this example of simply content on a website that other organisations may want to use, and this is, we understand, to do with sort of basic Q&A as to how you might deal with neighbourhood disputes. In this instance, it would simply be a matter of down here with the other material, you could include one of the Creative Commons licenses unobtrusively down the middle. It would be very much like we just saw here, where you can get a click-through license. So the symbol would allow for people to come across the material to readily determine the broader deed, the broader terms, should they wish, or simply from the fact of the symbol, they should be able to ascertain the terms on which they'll be able to use this material. And particularly if you're another legal assistance service that maybe want to simply replicate or click through this material from your own interface, it will allow you to determine very quickly if you're able to do that, or whether or not you might need to go talk to Quails and get their permission. I'll skip to the final one, which was an actual fact sheet, because I think it's also useful in the sense this is quite a busy fact sheet. There's quite a lot of content on it, and this again shows the utility of the symbols. That the other option for these sort of fact sheets is to, and this is again dealt with in the advice, is to simply have a line of text. So we've got down here, people may see a disclaimer, which is included, and I'll increase the size of this. There's a disclaimer already put there in terms of making clear it's not legal advice. A similar 1 or 2 line text could be put there in lieu of another symbol, which would simply note that it is a work licensed under attribution on commercial share like 4.0 international, and that, much like the symbols, is considered sufficient notice to allow any people viewing the material to know what license the material is being licensed under, and the terms on which they may be able to use that material themselves. Now, given the time frame, I understand there's like 5 to 10 minutes left, so I'm happy to take any questions that are in the room there, James.
Terrific. Given the technology that we're using, Kate, I might ask people to ask a question and then paraphrase it into the microphone. Might be the easiest thing yet. Okay. So
That'd be great.
Questions?
Could you just put it once at the front of your web page and then it will cover absolutely everything?
That's a great question. Kane, we were asked Can you just put it once on the front page of your website, or need it go on every single page?
Yeah, that's a good question. It's going to be a situation where a determination needs to be made as to what the work actually is. So if, for instance, you have a website on which you want to have the entirety of the website licensed under the same terms, i.e. you're going to treat it as a single work, then it may be sufficient to simply have the same symbol routed through the footer of all the web pages. But often you'll need to be, I think, a little bit more careful at determining whether or not there are distinct works being published on that website, particularly where you might have click-throughs to particular fact sheets. The other concern is going to be where you have particular web pages that might have images as well as text, and you'll be needing to make it clear on that page that the license applies to both, whilst there might be other pages where there's just text and you can make clear that it is just the text that you're asserting. So I think the easier way to do it is to make an assessment as to each bit of published content, as it were, particularly where it can be neatly or usefully viewed as a discrete unit, to be considered in and of itself, and for a determination as to the appropriate license to affix to that work made for that particular unit of material. And the other reason for that is as canvassed at the beginning, it's likely that different sets of material and different content that each legal assistance service publishes may be for slightly different purposes or for divergent purposes, particularly where there's content that may want to be reproduced in a fee-for-service training or similar presentation. So I think it's safer to, at least at the outset, although it might be time-intensive, to make an assessment across the board of all the published works that an organisation is putting out into the public sphere. And once done, it's then merely a system of maintaining, checking, reviewing those licenses, particularly as new works are uploaded or new works are published.
That sounds like a fun job. Thanks, Julie.
That's just what I was thinking.
Any other questions for Kane, folks? Catherine, can I ask if anyone's from the regions has come through questions? Right. So as I said, we'll be sharing that advice. It was advice that was provided to Wales because it's kind of hard for 20 different organisations to provide instructions to a law firm for this kind of advice. But we're happy to share that, and we'll get that sent out through Legal Aid as part of the follow-up to today's session. Can I, on behalf of everyone in this room and others who have tuned in from across the state, thank Kane and thank Ashurst for their support. I think this is a useful piece of information for us to have as we're thinking about ways we can do some of this stuff a bit better. And please thank Kane. The room's going nuts here, Kane. You might not be able to. Thanks very much, Kane. We'll speak to you soon.
Thanks, James. Let us know if there's any follow-up you'd like, and we're happy to chat.
Sure. All good.
Thanks, James. Bye.
Great. Thanks very much, James. That was a very useful session. I think we'll gain something out of that. So I think we've got about 15 minutes now before morning tea, so I might invite Maria back for a bit of a Q&A about website accessibility. So how does that sound? We'll have a demonstration break. Give me 1 minute. So I'll bring it up on the chart and I'll think it's yeah, maybe we should do that. What do you say now? I'm just sorting out another technical issue and then we'll come back to that.
We want to learn about accessibility, so you know. We were just saying we do understand.
Yes. Yes. Yes.
So really,
Yes. Yes. Camille, yeah, I spoke to her. Yeah. Well, I think last year sometime about yes. Yeah, so I've tried to convert them. Yeah,
it would be a website.
Oh, yes. I think there's one thing that's I think there's one thing that that's yeah, I just like well, at least you got to share with people just doing that. That's right. Yes, yes they do. Yes, so they can have one. Yeah, so on the handout there's a bunch of them that were recommended to us. So yeah, and we ran the website. And so just simple videos because that's mainly what we look at starting on with the videos. Yes, yeah. So
You've got to know.
So the you've got like a video pro was the actual writer. Yeah, no, we don't I think whether or not we get it out or
on a computer, which is
yeah, absolutely. Yeah, no, that's right. Just to get back into it, can't cover everything today. So yeah, and I mean, the more people at the moment. Yeah, I think
60 chapters. 40 chapters and it's been expanded. Some of the chapters now got 10 sub-chapters.
But it's still the same.
60 something chapters.
What our project is, probably 2 years, but it's very start.
There's 2 of us.
Yeah, well, there's 2 of us on our project. Pretty much the gold big. Yeah, but yeah. But after that, actually, we'll get back to it. We'll get back to it. Yeah. Because someone said things that Maybe this morning. She's got her own party now. Yeah. She did great work. Oh, that's just that's great. Very
Interesting to see whether
I'm going to say, like, pretty much what I'll be talking about is what's in that handout.
it's certainly true.
Extremely
interesting thing is Maria said just the other day, they just got 5 years out of the back in terms of review the history of the industry. And people saying, oh, okay, it's through. It's still using it. For 5 years down the track.
Yeah. And it's showing think it's just that it's shining correctly, but it's you're back to in the line. Actually, when you wrote that email, I remembered he had already mentioned that. Come back to it's funny, I was doing once you decide, yeah.
And I mean, and
having said that, it's I have to do it. Just it's yeah. Desktop computer, 30% connected computers now. So these things absolutely take. Yeah, good to see.
Yes, I know. When we first saw that, we were like, yes.
The same reading.
Yes. Okay, yeah.
So reading is something that one of the things that me as a books. You cannot read.
Well, it's the same thing. I do and like I was my channel.